So now I want to just tee up our first question here about whether or not a startup needs to patent an invention. So in the biotech world, obtaining a patent is usually a gating issue to getting a startup off the ground. So I would like to ask, at what stage should biotech startups start to think about obtaining a patent? If anybody has any input on that.
I'll start from a small molecule side, and I didn't say, but I'm a PhD organic chemist by training. So I work in the small molecule side of things, and maybe or a story to start with there. I mean, as we all know, it's 20 years from the time you file, right? And so the question is, when do you want that clock to start ticking? And so there's questions of funding, and there's questions of what's the best thing, overall value for the company. And I can tell you that at Quartet, we had a very interesting situation where we worked and licensed the IP from a European academic institution.
Okay.
So they had at least the foresight not to patent their invention at the very beginning because it was trade secrets at that point. Obviously, it was not known in the literature. Felt pretty good about a small molecule not being able to be scooped because you felt like you're in an area that was not, fully, terribly competitive. And so instead of actually patenting it and then licensing the patent to us, they licensed the option to acquire the IP, which meant that we didn't file the patent either. No one filed patents until we were very close to a drug candidate, and then we filed our IP. So that's a very unique situation where the investors were comfortable with that and actually thought that was a great thing. There was less to negotiate because it's only like a 7-page document versus like the 40-page document when we actually took that option, exercised that option to license the IP. So that's a different story, but you've got different funding at that point. And again, I think it's somewhat unique. So the moral of the story is, for a small molecule in a not competitive space, wait as long as you can. If there are concerns about being scooped, then it might be earlier, but then you could file broadly and figure that you're going to own the IP in that space and have a selection invention out of it. I mean, that gets into a lot of strategy questions, but I guess that's a couple of bounds of things that I can say on the small molecule side of it. So.
Thank you.
Yeah, I'd agree. I think that the decision also surrounds money, right? In terms of, and not only the cost of the process and so forth, but also whether you need external funding to support your program. If your startup, if you're in quote unquote stealth mode as you describe it, and you are not feeling competitive, I think he's absolutely right. The longer you can wait, because we've got a clock, right? Despite, I'm sure we'll talk about patent extension, Hatch-Waxman and so forth, but you're running out of time, right? So as soon as the patent is filed and then ultimately issued, hopefully, you're sort of, that's time that you would like to be on the market, but you've got a long development path in front of you, and it's eating away at that. So I think if you can delay it as long as you can, but if you're going to go seek external funding, most of the time you're going to need a patent, or
right.
to have applied for a patent.
So in my case, it was a little bit different from these two cases because mine is a technology, and there were other companies who were in the space but didn't have a similar setup as what we did with our technology. So if we did not, patent it quickly, we have the option that they could scoop it because they already had all the manufacturing capabilities behind them. So we had to once we figured out that it was a technology that we could commercialize, we had to go stealth mode for a good year and a half, where we filed the provisional patent, did all of the research to basically file the full patent, and we made sure that that coincided with the company rolling out and being founded, so that when we started going and talking to angels and investors, that we could say, we do have the patent pendings. We are, since I was at the university, I had to back license my own invention. So we could say we have, exclusive license to this patent. So those were all things that have to line up very quickly, because when you're manufacturing a device, you have to get the investors on board. So it put a lot more pressure. So we had to go very quiet for a while, get it all done, and then we could roll it out all together.
For me, it was very different in the sense that I was never going to build a company around what I had invented. As a matter of fact, I was never going to share my story. No one knew it. And the reason that I secured a patent was so that I could have the device manufactured in an ISO facility for my own personal use. And my intention was to sell the patent portfolio to a large entity that would then commercialize it. That was my real goal. That opportunity did come so we filed the patent, or I filed the patent with Mark in 2008, and in 2010 I did have an offer to buy the portfolio, and I turned it down because there was a clause, and you'll find that very early stage there's a clause that says there may be no commitment to commercialize. For me, I would have had an incredible return on my personal investment, financial. I really wanted to go back to the business that I had before because it was very successful and satisfying. But it felt morally and ethically corrupt. I couldn't do it, so I turned it down. And then shortly thereafter, I started to look at drugs, formulations. Other patients like myself, started educating myself on chemistry and physics and all of the things involved to continue. And that's when we went into stealth mode. And then at the same time I was going into stealth mode, I was trying to commercialize a device, worldwide commercialization, to be able to fund the advancements and the increasing size of the portfolio of IP.
Okay.